Good morning again, everyone. Welcome to the first BBBA webinar. Thank you for all the attendees that logged in on time. We gave 5 minutes to those who are a little bit late. More people will be joining in along the way. We have close to 100 registered participants, which means that we have more than tripled the interest towards the BBBA business regulatory update compared to the live event last year. This is on the one hand definitely due to the excellent presenters and interesting topics that we have on the program, but also due to the new normal, which is online. I hope all of you are safe and healthy, and your families and also your businesses are handling the new situation well. We have quite a big and heavy program today, but before I hand out the microphone to our first presenter from Penev LLP, Biljana, I would like to give you a few technical details. All of you are on mute today, and you will be seeing the presentations on the screen. No videos today, neither from the presenters nor from the group, from the attendees, because we have quite a large group. If you would like to ask a question to the panelists, please use the Q&A section in the panel that you have on the bottom of your screen. Each presenter will have a total of 20 minutes, 15 minutes for the presentation and 5 minutes for answering questions, which means that probably the presenters will have 3 or up to 3 questions to answer during the session. But don't worry, all the questions that you have asked that remain unanswered during the webinar will be answered either in a conversation following the webinar or in written form, because the panelists will have all your questions in the presentation. You will also receive all the presentations afterwards, so don't worry about that. Don't take too many notes. Without further ado, I would like to give the floor to our first presenter, Biljana Bayraktarova. Biljana, the floor and the mouse is yours.
Thank you very much. Good morning, everyone, and welcome to today's webinar. My name is Biljana Bayraktarova, and I'm Associate Attorney at Penev LLP Law Firm. I'm delighted to be here today to tell you about the legal aspects of the trade secrets protection in Bulgaria. My presentation is divided into 5 sections and 5 questions to be answered in the course of my talk. These answers aim at providing you with a better understanding of what is actually a trade secret and how can you protect it in view of the definitions and requirements of the legal framework in Bulgaria. And those questions are: what information qualifies as trade secret? What are the limitations on the trade secret rights? How to protect your trade secret? When has a trade secret been misappropriated, and what can you do when your trade secret is breached? So, before I start with the indicated questions and their answers, of course, I'd like to give you some background information about the general legal framework related to the trade secret and its protection. At the European Union level, the trade secret protection is regulated by the so-called Trade Secret Directive. In Bulgaria currently, various legal acts contain provisions with respect to trade secret protection. The first one to mention is the Bulgarian Trade Secret Protection Act, adopted in April last year as a result of transposing the said EU directive. The Trade Secret Protection Act sets forth the definition of trade secret and trade secret misappropriation, as well as the conditions and the requirements for the civil proceedings which can be initiated in case of trade secrets misappropriation. Further, in the context of unfair competition, trade secrets protection is also governed by the Bulgarian Protection of Competition Act. Additionally, the Bulgarian Commercial Act contains also provisions which specify how, for example, the commercial proxies or commercial representatives are obliged to protect the trade secrets of their principals. On a separate note, the Bulgarian Labour Code regulates the obligations and liabilities of the employees who misappropriate the trade secrets of their employer. So much for the legal framework. Let us move on to the more important part of this presentation, our questions and answers. And that leads us to our first question, which is what information qualifies as a trade secret? So in order for a given information to classify as a trade secret, it has to meet all of the following requirements. On the first place, it has to be a secret in the sense that it is not now or readily accessible to a wide circle of persons who normally deal with that type of information. On the second place, it must have commercial value. And finally, it should have been subject to reasonable steps to be protected by the person lawfully in control of the information. In the course of this presentation, I will shed some light on the separate elements of the mentioned definition, so I'm not going to elaborate more on this slide. To illustrate the previous slide, I would give you some examples. The subject matter of the trade secrets is usually defined in broad terms and includes, for instance, business methods, pricing information, personnel information, process know-how, marketing data and planning, manufacturing techniques, etc. And now, knowing what information can be classified as trade secret, let us turn our attention and quickly indicate some examples of what are the limitations on our trade secret rights. For instance, there is no trade secret breach in case of reverse engineering. That is when someone, by means of observation or testing of a product that has been made available to the public, discovers a trade secret. The trade secret protection is limited to the advantage of those who reveal misconduct, wrongdoing, or illegal activity. Further, there is no trade secret misappropriation if the disclosure of the trade secret serves the public interest. The companies are not allowed to restrict the workers and the employees to use the experience and skills acquired in the good faith in the course of their work. I would like to not expand on this aspect further, as this point is only to briefly outline that not any conduct of acquisition, use, and disclosure of trade secrets constitutes trade secret misappropriation. Let me go back to what I said earlier. In order for an information to be qualified as trade secret, it should be confidential and secret and subject to reasonable protective measures. This was part of the definition of the trade secret. It is therefore very important for businesses to take appropriate measures to keep information of great commercial value secret in order for it to qualify for protection. So the protection of trade secrets starts at organizational level by setting up special procedures for identifying and specifying what information exactly is to be classified and treated as trade secret. Employees should be trained and informed about the company's trade secret policies and procedure. Helpful tools to keep information secret are also the non-disclosure agreements and the confidentiality agreement. Signing such agreements could prove useful before disclosure of any valuable business information at the negotiation stage. It is additionally recommendable to implement technical protection measures in order to secure trade secrets from both external threats and potential thefts from inside the company. I would like to draw your attention to this point, as it should be emphasized that if a company did not take respective protective measures to maintain the secrecy of its confidential information, the same would not be able to argue and prove at a later stage that its trade secret has been breached. So now, we know what is a trade secret, its limitation, and how to protect it. Let us turn to the next question, which is, when has a trade secret been misappropriated? So there are three main forms of trade secret misappropriation, namely unlawful acquisition, use, and disclosure of a trade secret. Let us start with the first one. What is an unlawful acquisition of a trade secret? This is the acquisition of a trade secret without the consent of the trade secret holder. And this could be, for example, any unauthorized access or copying of any documents, object, materials which contain the trade secret or from which the trade secret can be deduced. Additionally, any other conduct which is considered contrary to the honest commercial practices could qualify as unlawful acquisition of trade secret, decided on a case-by-case basis. What is unlawful use and unlawful disclosure of a trade secret? Yes, we're on the right slide. So this is again any use or disclosure of a trade secret carried out without the consent of the trade secret holder by a person who either has acquired the trade secret unlawfully or is in breach of a confidentiality agreement or any other duty not to disclose a trade secret, or is in breach of any other duty to limit the use of the trade secret. So this relates to what I said earlier about the importance of the trade secrets related protective measures. This is why it is crucial for any company to develop its trade secret policies and procedures and to sign non-disclosure agreements and confidentiality agreements, because such actions taken by the companies will entirely facilitate the process of proving that first, there is a trade secret subject to protection, and second, that that secret has been breached. With regard to the trade secret breach options, we may have two interesting scenarios. I'd like to illustrate the first. Excuse me, the right slide is here. Yes, I'd like to illustrate the first one by showing you this flow. First, we have a person, an employee, current or former of the trade secret holder, who without the consent of the trade secret holder has acquired and disclosed his trade secret to a third person, a competitor. The third person, the competitor, could be liable for unlawful acquisition of the trade secret if, despite of the fact that the latter was not actually the one who, without the consent of the trade secret holder, initially acquired and disclosed the trade secret. This would be the case if that third person, the infringer, the competitor, upon the acquisition of the trade secret, knew or should have known that the information was disclosed by the employee without the consent of the trade secret holder. In this scenario, the trade secret holder can initiate not only judicial action against the employee, but also against his competitor and claim, for example, compensation for the damages suffered and prohibition of the use of the trade secret. This is an interesting scenario because usually from business perspective, the companies are more interested at suing their competitors for unlawful acquisition of the trade secrets than at suing their employees. And let us move to the second specific scenario, which relates to an unlawful use of a trade secret. This is when, in our previous case, our competitor hires the former employee of the trade secret holder, and that employee uses the unlawfully acquired by him trade secret to design and produce goods for the competitor, his new employer. The production, the offering, the placing on the market of these goods constitute an unlawful use of a trade secret for which the competitor would be liable if, carrying out these activities, he knew or ought to have known that the trade secret was used without the consent of the actual trade secret holder. Again, in this case, the trade secret holder may also bring an action before the court and ask the court to prohibit the production, offering, and placing on the market of the infringing goods. And this leads us to the last questions to be answered in this presentation, which is what can we do when our trade secret is breached? Pursuant to the Bulgarian Trade Secret Protection Act, upon trade secret misappropriation, the trade secret holder may bring an action before the court seeking one or more of the following measures: compensation for the damages suffered and loss of profits, the prohibition of the use or disclosure of the trade secret, the prohibition of the production, offering, placing on the market, use, importation, export, or storage of infringing goods, the destruction of documents that contain trade secret or, where appropriate, their delivery to the trade secret holder, the prohibition of offering or providing the services which significantly benefit from trade secrets that are breached. Additionally, at the request of the trade secret holder, the court may order withdrawal of the infringing goods from the market, eliminating the trade secret characteristic from the infringing goods or services, or destruction of the infringing goods. I'd like to elaborate a little bit more on the compensation for damages and how its amount is to be determined by the court. Generally, the trade secret holder shall be indemnified for any damage suffered and loss of profit, which are a direct and immediate consequence of the trade secret breach. The compensation is due when the infringer knew or ought to have known that he/she was engaging in trade secret misappropriation. There is, however, a limitation of the employee's liability if the employees have acted without intent. In this case, the employees are responsible for the damages suffered to the amount not exceeding the triple amount of their remuneration. It is worth mentioning that prior the court claim or during the court trial, at the request of the trade secret holder, the court may order precautionary measures against the alleged infringer. They are listed on this slide, and for example, such a precautionary measure is the prohibition of the use and disclosure of this secret on a provisional basis. Upon determining the precautionary measures or the final measure to be taken against the infringer, the court takes into account the specific circumstances of the case and considers inter alia, for example, the value of the trade secret, the measures taken to protect it, the impact of the unlawful use or disclosure of the trade secret, the legitimate interest of the parties, the public's interest, etc. And now, as part of the answer to our question, what can we do when our trade secret is breached? And just to round the talk off, I want to go back to the beginning when I explained the legal framework governing the trade secret protection regimes. This is also part of that answer. In Bulgaria, in the context of the unfair competition, trade secrets protection is also governed by the Protection of Competition Act, which prohibits the obtaining, use, or disclosure of production or trade secret when inconsistent with fair business practices. The use or disclosure of production or trade secret is prohibited also in cases when the secret is obtained or provided under the condition not to be used or disclosed. There are no restrictions or limitation on the information which qualifies as production or trade secret, as long as such information is not public and relates to business activities. However, as per the case law, it is necessary that the proprietor of such information has determined in a clear manner what is considered to be production or trade secret. Upon breach of the fair competition, proceedings before the Competition Protection Commission may be initiated. If the Commission finds that a violation has been committed, it will order the discontinuation of the violation and impose a pecuniary sanction. Since the sanctions imposed are of purely administrative nature, the Commission cannot award damages to the aggrieved party even if it has found a violation of provision of the competition rules and has sanctioned the infringer. The possibility for sanctioning the infringer under the rules for protection of competition exists independently of any other remedies available to the trade secret holder whose rights and interests have been violated. The trade secret holder may claim compensation for damages on the basis of the Bulgarian tort rules before the courts. Further, under the Commercial Act, commercial representatives, commercial agents, and intermediaries must keep keep in confidence the trade secrets of the person who have assigned them performance of specific work. Similar confidentiality obligations are imposed on members of the management bodies of joint stock companies. On a separate note, the Labour Code provides for the duty of loyalty of the employees, which encompasses, among the others, the obligations of the employee not to disclose confidential information of the employer. The Labour Code does not contain an express definition of confidential information. The case law considers as confidential any information that is clearly indicated as such, save for information which is well known to the people working in a particular field. Violation of a statutory obligation for confidentiality by the employee may lead to disciplinary sanctions, for instance dismissal, as well as may trigger the employee's pecuniary ability. In conclusion, considering all said, I would like to provide you with some recommendations on how to deal with and protect your trade secret. First of all, assess your valuable business information, ascertaining the best option for its protection. Then develop internal trade secret policies and procedures and start storing the confidential information safely. Further, create awareness and train your employees for keeping trade secrets safe. Don't forget to execute non-disclosure agreements with business partners and contractors, and include non-disclosure clauses in any agreements where exchange of confidential information is likely to occur. In case of trade secret misappropriation, consider best protection provided by the applicable law in light of the Bulgarian Trade Secret Protection Act, the Protection of Competition Act, and the Trade Code. And this brings me to the end of my presentation. Thank you for your attention. It was a pleasure being here today.
Thank you very much, Biljana. I see no questions in the Q&A section. I would like to invite again the attendees. If you would like to ask a question to Biljana, kindly write a note in the Q&A section. We have a few more minutes for Q&A with Biljana. If not, you see her details on the screen, so you can definitely contact her after the presentation, after the event today. And of course, you can schedule a meeting or you can exchange emails. No questions? Probably because your presentation, Biljana, was all in the Q&A form, so maybe you answered all the questions during the presentation.
That was the point.
Thank you very much for that. And now I will, we have one question. Biljana, you see the question from Martin Gold. Thank you, Martin, for the question. It says, is the order book of a company or the listed customers regarded as a trade secret?
Yes, the list of the customers can be regarded as a trade secret.
Okay, that was a short answer. And Martin is happy with the answer. That's good.
Thank you, Martin. Thank you for your question.
Thank you. So now I suggest we move on to the next presenter in our webinar. Thank you, Biljana, again for being first and to kicking off this morning.
Thank you for your attention.
Now I would like to pass the floor to Asen Apostolou from Penkov, Markov Partners, who will tell us about the practical aspects of UBO identification, registration, and the latest development in the AML legislation. Asen, please go ahead.
Hello, everyone. Okay, here it is. After that intriguing presentation concerning the trade secret, I would like to share with you a brief update on the latest developments in the anti-money laundering field, along with maybe one or two interesting cases which our legal team at Penkov, Markov Partners has been part of recently. Just wanted to very quickly thank BBBA for the great opportunity to participate in this webinar and share some of our practice in the ML sphere. Thankfully, the tense events from the past weeks did not influence our meeting today. By way of a very, very brief introduction, I'm a Sen Apostle of Attorney at Law at Penkov, Markov Partners. In the last 4 years or so, I have been an integral part of the ML team of PMP, advising clients from various different businesses and spheres, payment and financial institutions, wholesalers, NGOs, etc., etc. So here is a brief summary of the topics which I would like to cover today, shortly cover today, with the aim to give you a little bit different perspective and examples on the discussed subtopics. The first one is named the legislator versus the regulator versus the court, where the idea is to give a practical example of how those three could make a bit of a mess with the application of a legislative act, in our case, when it comes to UBO registration. Then a few words about the latest legislative developments in the sphere. Firstly, as regards the identification of UBOs, and then as far as the Bulgarian national risk assessment is concerned. Lastly, I'll be glad to share with you an interesting, in my opinion, UBO structure and its brief analysis, just as an example of how such structure could turn out to be something different from what it looked like in the beginning. Okay. You know, in such challenging times we're currently living in, probably the ML topic won't be the one which will lift our spirits, especially having in mind the current ML status in Bulgaria, in terms of legislation, application of new requirements, perspectives, etc. This is why I wanted at least to try to start with something that some may call funny, whereas others will probably name it frustrating. These are two quotations from a court decision issued by Sofia City Court. It was issued as a result of an appeal submitted by our legal team against refusal of the commercial register to announce the ultimate beneficial owner of one of our clients. From my personal perspective, these quotations are unfortunately kind of embodiment on how the practice develops in terms of UBO registration in the public registers. Here are the two quotations. If there is anything clear in the law applicable under this case file, that is the intent of the legislator to identify the natural person's ultimate beneficial owners. As you can imagine, the law applicable under this case file is the new Bulgarian AML Act. And here's the second quote. This one is my favorite. The specific manner in which the company applicant, that's us, should fulfill its obligation to register its UBO in the commercial register could be subject to either more precise legislative technique, or two, very broad and practically a random interpretation of the law. Such manner in any case could not be the one indicated by the applicant based on the alleged mandatory instruction of the regulatory body in the field, the State Agency for National Security, and the presented agency interpretation, where the provision of the law has simply been cited with all ensuing from its wording ambiguities. What do we understand from these quotations? I think, A, what is the attitude of some of the judges towards the wording of the law, which in turn inevitably is a prerequisite for the controversial practice currently established on various different matters under the AML Act, and especially when it comes to UBO registration. And we understand also, B, that some of the judges do not accept the interpretations provided by the supervisory body in the sector, the State Agency for National Security, which is in fact the state authority supervising the activities of the obliged entities in the AML sphere, the authority imposing sanctions for non-compliance with statutory obligations, and the authority to which practitioners and companies, of course, refer their requests for interpretation of the law. In other words, and as a bottom line here, there is no predictability on the way the State Agency for National Security or the court will apply or interpret the law at this point in time. So when it comes to application of the AML Act, drafting of internal AML policies and procedures, conduct of KYC procedures, etc., the more strictly and diligently your company follows the formal obligations prescribed in the law, the better. My idea is do not underestimate this aspect of your company's activity, even if naturally, of course, this is not your first priority, especially at this moment in time. Okay, jumping straight from the UBO registration into the UBO identification as part of the customer due diligence process performed by the obliged entities. I do not want to go to the basics of the UBO identification, but rather tell you about a couple of interesting cases which our team had in the pipeline recently. I think it is important to mention here an amendment which was implemented in the law as of December last year in relation to the transposition of AML-D5, the fifth AML directive, which was implemented in the Bulgarian AML Act. It concerns the UBO identification as part of the customer due diligence of a client performed by an obliged company. The change, could have practical significance. Up until December, the UBO identification should have been performed by conduct of a check in the commercial register, where the UBO should have been registered, by obtaining other documents which to certify the UBO should be visible from these documents, for instance, book of shareholders on the company. And 3, by obtaining UBO declaration. The sample is provided in the regulations on the implementation of the AML Act. All these 3 measures should have been undertaken altogether. As a result of the amendments in the AML Act, the sample declaration for UBO identification is not mandatory anymore for obtaining upon identification of UBOs. It should be required from the client only in case the other 2 measures, the check in the commercial register and the other documents evidencing the UBO, are not sufficient to certify the UBO, or in cases where, of course, there is a controversial information on the UBO identity. I decided to put some focus on this amendment because recently I received quite a few inquiries on its practical implications. I would say that irrespective of this law change, in my opinion, most companies and obliged persons shall continue to require the UBO declaration from their clients just as an additional confirmation of this circumstance, rather than relying only on the other 2 measures. Actually, the credit institutions, the banks are a good example in this regard. I personally also think that such approach should be backed. Speaking about the latest developments in the AML field, of course, we could not miss to mention the publication of the Bulgarian National Risk Assessment. Just a few words here, since this is, of course, an important topic which could be discussed in much more detail. The NRA points out that 32 money laundering risk events and about 10 terrorist financing risk events. The document aims at outlining certain risk factors which could have impact on the risk assessments which are drafted by the companies. These risk factors concern the customer and its UBO, the country or the geographical zone where the customer or the UBO are registered or the UBO resides, the products and services offered and the type of transactions operations performed, and the delivery mechanisms used for the product services transactions. What, in my opinion, is important to be outlined here is the 6-month term commencing as of publication of the NRA, 9th of January 2020, within which all obliged entities should adjust their internal AML policies and procedures with the requirements of the new AML legislative framework. The term lapses on 9th of July, and frankly speaking, I'm not sure that it will be prolonged due to the current situation worldwide. My advice here is do not leave these compliance matters and questions for the last minute. Draft or adjust your internal AML documentation, individual company risk assessment, etc. in advance. Because I have to go back to point 1 of my presentation. Unfortunately, there is no predictability on the manner in which the new requirements will be applied in practice by competent state bodies, including when it comes to court appealing against acts of the State Agency for National Security. Okay, lastly, I wanted to briefly go through an example for UBO identification procedure, which our legal team was recently engaged in. This is what usually comes as a challenge to our clients, how to identify my own UBO. There is a complex definition in the AML Act on what actually UBO is. there are, of course, also many other additional resources in this regard, including a 200-page guideline of the FATF. Of course, we will simplify the example so as to take into account only two criteria when identifying the UBO. The first one is 25% direct, indirect ownership of shares. And the second one is 50% plus voting rights in a company as criteria for exercising control. Here is our example. This is a corporate structure consisting of companies established in different member states, Bulgaria and Germany. What is interesting here is that part of this structure are the so-called limited partnerships, Kommanditgesellschaft in German, excuse me for my pronunciation in German, where the liability of part of the shareholders is limited to the company to the capital contributions made, whereas the liability of the other shareholders is unlimited. In other words, they are liable with all their personal property for obligations of the company. So here is our target, our client fully owned by M, which in turn is subsidiary of company J. Up until company L, we have 100% ownership of each entity, Z and Y, and the corporate chain continues uninterrupted. Then it turns out that K holds 98% of the capital of L, virtually exercising control over the company. So my analysis at the time continued in the right part of the organigram, where Q owns 100% of the capital of K. And here comes the interesting part. We have 8 shareholders in Q, only one of which is a natural person. Here it is, owning 100% of the capital of Q. At first, when analyzing this structure, I was like, okay, this was easier than expected. We have a natural person owning 100% of the capital, so this should be the UBO. Soon, however, I was provided with additional information on the influence which each of these 8 shareholders has in company Q. Namely, the natural person indeed holds 100% of the capital. However, the voting rights in the general meeting of Q are allocated at about 14% per each shareholder, where one shareholder, in our case H, even does not have any voting rights. In turn, this means that none of the shareholders exercises control over Q, including the natural person owning 100% of the capital of the company. We have unclear control. It turned out that the shareholding participation does not correspond to the voting rights in the general meeting of Q. It's interesting to consider also that when you check the left part of the chart, it appears that A controls D. And this is a circumstance which have impact in the right part of the organigram, in the general meeting of Q, where in practice, A votes with its own 14% voting rights, plus the 14% voting rights of D, due to the fact that A controls D. So as the chain of control was terminated above Q, no natural person could be identified as UBO, and the CEO of the Bulgarian company was announced as such. You know, it's not a coincidence that this structure was established in this particular manner. What should be put focus on here, in my opinion, is that when identifying UBOs of companies which have foreign shareholders and structures established in other states, we should also take into account the specifics of the foreign company legal forms, which could have significant impact on the influence exercised in the legal entities part of the structure, and eventually, of course, on the conclusions made as a result of the UBO analysis. And this is exactly the case here. Okay, thank you. Thank you so much for your time and attention. Of course, I will be glad to look into your questions if there are such, and give you my opinion on any such queries.
Thank you, Sen. Now I would like to invite the guests to write their questions in the Q&A section, if you have any. We have time for a couple of questions, so if you have any, please go ahead and ask. Otherwise, of course, you can follow up with the SEN on the email that you see on the screen now. By the way, Biljana, you have one more question in the Q&A section that was asked just a couple of minutes after you muted yourself. So if you would like to respond in writing, you can do that in the Q&A section now or follow up with Tim after the session.
Thank you. I'll look at the question and and I'll answer it. Thank you very much.
Thank you, Biljana. Now, as I see no questions for Sen, I would like to thank him once again for the presentation and to invite our next speaker, Denita from Kambourov Partners. I would like to thank Denita for completely changing and writing from scratch her presentation this week due to the changes in our society and business that are happening right now related to COVID-19. So Denita, you're welcome to tell us a bit more about the tax measures adopted in Bulgaria, UK, and the EU regarding COVID-19. The floor is yours.
Good morning, everybody. Just as a quick introduction, my name is Denita Dimitrova, and I'm the head of the tax department of Kambourov Partners. I spent about 15 of the last years of my life in the tax and legal departments of TMF, KPMG, and Deloitte. And since last September, I joined Kambourov Partners with the goal to create a new service line and to expand their current tax litigation practice. I hope you're all doing well in this new situation. As Desi mentioned, we decided together to change our presentation in the last moment. The reason for this is because our previous subject that we're going to present about, but quick fixes in Bulgaria and the European Union, in our view, was not very actual at the moment, in a time when the businesses are struggling to move their goods. The VAT quick fixes leave a little bit behind the schedule of our society and the businesses as a whole. And that is why we took this decision. For those of you who subscribed for this webinar and for the conference because of the VAT quick fixes, I would like to say that we're going to send the presentation about the VAT quick fixes along with the presentation about the COVID-19, and also will provide actual information about the percentage of implementation of the VAT quick fixes across the Europe. As a matter of fact, the percentage is quite low still. So the implementation of these new measures of the European Commission in terms of VAT leave behind schedule too. Where we should start. I'm sure most of you are already aware of the measures that our government and parliament adopted in the last couple of days and weeks because of the announced state of emergency in Bulgaria. There were different drafts and proposals. And finally, 2 days ago, we had the state of emergency law published in the Bulgarian State Gazette, and we're officially in this new situation. Along with all the epidemical and other hygiene measures, home office, and everything. There are, of course, tax changes and tax measures that our government have adopted. Our presentation today is not aimed to be exhaustive and to cover all the situation and cases that will arise as a consequence of this new law. But we decided, after all this juggling with this hot potato in the media, in the business, in the parliament, all the statements of politicians, public figures, and business people, to put in a very simple way in this presentation what is going on in Bulgaria, what is going on in the UK, and what is going on across Europe. The purpose is not to compare our tax relief and measures with those in the other countries, but to support in a very practical way the businesses that are located not only in Bulgaria, but also in other countries. And for example, we have multiple VAT registration, pay taxes, not only in Bulgaria, but in other EU countries. The time, unfortunately, is not much. That is why I suppose that today we will focus only to the Bulgarian measures. If we have time, I will try to explain also a little bit about the UK, and the rest of it you will get it after the webinar with the presentation. Also, we are going to publish on our website and provide it to our partners from the British Association to be provided to its members. And in the next couple of days, we will also publish the tax measures of the whole world globally for all the countries where the COVID-19 created the need to adopt such measures. The truth is that nowadays the coronavirus poses extreme challenge to all citizens and governments of Europe. Infected person increase exponentially from day to day, and of course, to limit the spread of this new virus, new regulation and significant restrictions in public life are being introduced in Bulgaria and in all European countries, as we all know. All companies, of course, are struggling with the negative effects of this situation. The European Commission has already announced the Corona Response Initiative with a volume of 25 billion euro to support affected companies, and also additional state aid amounts will follow. The Commission is trying to simplify the procedures and the structures in order as many as possible companies, businesses, and people to receive from this money, especially dedicated for the fight against the coronavirus. And just 2 days ago, this is not part of the presentation, the Commission announced that they will allow additional state aid up to 800,000 euro per business. Of course, all European countries themselves have adopted tax simplifications and tax relief measures to support companies to cope with the economically disadvantaged situation. And we monitor the situation on a daily basis. So please feel free to contact us at any time for more and updated information. We'll be very pleased to assist you and give you further advice. We don't claim that we have the answers of all questions. We're seeking for these answers in the last couple of days, though it's quite difficult to find them because of the rapidness of the adoption of the new measures, some inconsistencies in the new legislation, and some unclear issues that still remained unanswered. Taxation and reporting. We will start with the extensions of the terms for reporting and paying the corporate income tax and advance payments provided to the business. So until 30th of June is extended the deadline for reporting and payment of the corporate income tax, including the expenses tax under the Corporate Income Tax Act. Also, all these categories of persons like sole owners of businesses, or the so-called sole traders, and the agricultural manufacturers who have chosen to be taxed as sole traders will follow the same extensions as provided for the businesses. In addition, in order to enjoy the 5% deduction of local taxes for real estate and vehicles, will also be extended until 30th of June. And the deadline for reporting the absence of operations. These are all the extensions until 30th of June. Until 31st of May is extended the deadline for 5% deduction provided in the income taxes in the physical persons and additional tax payments, again, for these categories of persons, sole traders and agricultural manufacturers. Unfortunately, in our view, all the other taxable persons, including the self-employed taxable persons, will continue to follow the current deadlines. I mean, the deadlines which were valid before the State of Emergency Act was adopted. Nothing is changed for them, so they're not going to enjoy any extension. The same is applicable for their advance payment installments. As to the publishing of the annual financial statements and all other financial statements and consolidated and the annual reports, the deadline is extended until 30th of September. And also, the monthly advance payments for the businesses are extended until 50th of the month following the quarter in which they are due, which can be viewed also as certain relief for the business. Here it is mentioned in detail about all the quarters in 2020, how the advance payments will be extended. Also, the advance payment for the fourth quarter is not due. It is clearly mentioned that the annual financial statements can be signed electronically. We checked with the electronic signature service provider, the trust services providers in Bulgaria, and it seems that some of the trust services providers in Bulgaria already adopted new procedures for receiving and obtaining electronic signature distantly like Eurotrust electronic services provider. However, the National Revenue Agency did not react in the way we expected. And still, if those persons want to submit electronically, I'm not talking only about annual financial statements, but also for any kind of reporting that is due with the tax authorities, they will have to go in person and present their original power of attorneys with the National Revenue Agency. We hope this will be changed shortly, as otherwise some of the companies which are newly registered and, for example, have to submit annual financial statements for the first time or tax declarations, they will experience problems in registering their electronic signatures with the National Revenue Agency. At the same time, the agency announced as a strict recommendation to all physical persons and businesses not to visit the offices of the National Revenue Agencies. To be clear, all other deadlines for establishment, reporting, or payment of taxes, and here we are talking about VAT, excise, and customs duties, and social insurance contributions remain unchanged. Forgot to mention about the self-employed people, that they will continue to follow the deadlines as they were in place before the adoption of the State of Emergency Act. So next slide, please. We have 5 more minutes left, so I'll try to be quick. Another important measure adopted by the government is the right to refund 60% from the Social Security income for employees that may lose their jobs. 2 days ago, the government released the criteria and the type of businesses which will be covered by this measure, and unfortunately, again, in our view, the scope is very limited. We're talking about transport companies, hotels, certain entertainment, restaurants, bars, the business, the touristic business, and the sport activities, which is quite limited, and we really hope that with the time they will extend the scope of this measure. Though our calculations show that the real support after the calculations of the Social Security contributions and the income tax that is due by the employee, the real effect will be not 60 but 20% in monetary terms. Another important measure is the Statute of Limitation and the terms under the tax procedural law in Bulgaria. Those are suspended. Also, the terms of the court proceedings under tax cases. The interpretation of the National Revenue Agency showed that, in fact, the tax control procedures are not stopped, and all currently assigned tax audits and tax checks will continue in the way they usually are conducted. Also, the terms for regular VAT refund procedures will not be affected, which is a good thing. It's questionable whether penalties and interest for late filings and payments of taxes could be waived, and we shall see how the authorities will interpret this in the future. Just one last sentence I will mention about the public enforcement procedures, which are stopped, except here on the slide we mentioned the exact expression of the law. Still, there are not definitions. What is important state or public matters? The enforcement may be precluded or seriously disturbed, or significant damages may follow. We shall see, because this consideration remains in full prerogative of the revenue authorities. And the next slide, please. The public enforcement, however, will continue by initiative of the taxpayer to impose security, distribute amounts, reopen the procedure following the taxpayer request. And it should be noted that during all the public enforcement procedure, notwithstanding the fact whether they're stopped, penalty interest will still be accumulated. And for those of you, maybe some of you have some pending cases in front of the Court of Justice of the European Union, the court announced that it will continue its work. So the state of emergency across Europe will not affect its proceedings, and all the companies should strictly obey and follow their deadlines. And I think we have 1 more minute for some questions, and you will have the possibility to read the tax measures. We try to put them in a very simple and structured way in the rest of the presentation. And of course, if you have any questions, you may freely contact me. Desislava will provide my contact details, including my mobile telephone. So don't hesitate to contact us. Thank you very much for your attention. I know this was not an exhaustive information analysis and analysis. Unfortunately, the time is limited, so we may continue after the webinar.
Thank you, Denitsa, for the presentation. It was not exhaustive, but it actually covered the topic of the day, and I'm sure it's important for everyone. I don't see any questions in the Q&A. Maybe you were very clear. Just to remind the attendees that you're welcome to write your questions in the Q&A section. And although we have reached the time limit for this presentation, I'm happy to give a few more minutes if you would like to ask a question now. If not, you see Denitsa's email on the screen, so she can respond to you afterwards.
I just want to mention that I will be online during the whole webinar. So if somebody has a question, I will be able to answer in the Q&A section.
Great, thank you, Denitsa. So in this case, if there are no questions at this moment, I suggest we move to the next presentation, which is again on a very interesting topic. It's a presentation from Oleg Temnikov from Theiss, and the topic is the new EU Whistleblower Protection Directive. How will it impact businesses and how to prepare? Oleg, the floor is yours.
Good morning, everybody. just to present myself in a couple of words, I'm Oleg Temnikov, and I'm a counsel at Theiss law firm in Sofia office. This is a regional law firm present in 13 jurisdictions in the Eastern Europe. But our Sofia office, it's one shop law firm present in Bulgaria for 10 years. Now, my presentation will focus on a topic which has not yet really come to Bulgaria, but definitely it will in the next couple of years, and probably it will change more things in the business than the data protection and the IML regulations did in the past 2 years. The whistleblower protection per se, it's a concept which is not really used in our apologies, yes, which is not really used in Bulgarian legislation. But now the European Union will make mandatory for member state to bring such mechanisms in our domestic legislation. Now, recently we have been seeing in the last years a number of big financial or political scandals which appeared exactly because of whistleblowers. We can see in many sectors like the financial sectors, and we can just remember the Panama leaks, or sectors like public procurement, like product liability, of course, environment, public health, where the public interest has been really protected, or at least some issues have been flagged exactly because of whistleblowers. Now, how everything started at the European Union level. Traditionally, the whistleblower protection has not also been very used in Europe until maybe 15 years ago. Then, historically, in a number of cases appeared, like the Mediator weight loss drug scandal in France in 2013, like the Luxembourg leaks in 2014, Dieselgate in 2015. So, number of situations where the authorities of EU member state or European Union authorities have been warned about serious breaches of European Union legislation or of national legislation by people which were actually working in a respective company or working in a respective public body, which people had the courage or consciousness to, or were motivated by other reasons, of course, to blow the whistle about issues they see. Now, what is the problem? History proves that those who raise the alarm are often exposed to very high risk for their career, for their livelihood. In some cases, they can either suffer financial hate, health, reputational, or personal repercussions. We know many examples in this respect. For instance, the UBS case, where some of the employees of UBS which helped to blow the whistle of the irregularities were fired, were persecuted by Swiss authorities. Similarly, with the WikiLeaks case, where person which blow the whistle has been in jail in the United States for many years, etc. Then this makes necessary the protection offered to whistleblowers across the European Union to be unified. Currently, the situation is that it's fragmented, and we'll see in the next slides, it differs from country to country. But if the European Union wants to achieve a single market where the public interest of the Union and the member states are protected in a homogenic way, then a single framework should be adopted. And this is led to from the understanding that the better protection would be achieved at Union level with common minimum standards. Now, before continuing, I wanted to give a very short historical background of whistleblower protection. Everything from legal point of view started in the United States back in the 18th century during the US War of Independence, where the Continental Congress adopted special legislation to protect whistleblowers for wartime crimes. It adopted rules to protect officers from the Navy and sailors who blow the whistle about irregularities in respect of English soldiers. So this is the very first example of such legislation to protect the situation. Then historically, in the 20th century, special legislation has been passed in US, which created very strong protections for whistleblowers among many sectors, including the public sector, including pharmaceutical companies, companies in the defense sector, financial companies. What is the status in Europe? In Europe, some of the European Union member states have already adopted broad-ranging whistleblowing legislation in order to protect whistleblowers. Of course, the United Kingdom, not a member of the European Union as we know anymore, but the United Kingdom had such legislation starting from 1998, the UK Public Interest Disclosure Act, and it's one of the earliest pieces of legislation. It has been adopted, and it proved through the years that it was very efficient to allow whistleblowers to be motivated to blow the whistle to reveal some irregularities. Similar legislation followed, for instance, also in France with the Sapin 2 law adopted in 2016, which requires a number of organizational measures to be put in place in order to protect whistleblowers. Those measures affect not only the public sector, it affects private companies, which are obliged in France to have internal systems where people who see irregularities may go and in an anonymous way reveal those facts. And actually, in France, this mechanism revealed very, very useful, especially as it concerns tax fraud. Similar views have been also expressed by the European Court of Human Rights, which has been constant in affirming the right of whistleblowers to freedom of expression and protection against retaliation. Now, what about Bulgaria? Bulgarian legislation traditionally does not have provisions in this respect. On the contrary, for historical reasons, the whole idea of whistleblowing, of revealing irregularities, had some negative connotation, especially after the socialist time. Now, with the implementation of different European Union acts and regulations, this has been changed. For instance, the Measures Against Money Laundering Act contains some limited, but still some initial elements of whistleblowing protections. For instance, companies should create internal channels for anonymously and independent reporting of breaches of the AML regulations. There are also some rules on external reporting. Similar provision have been provided also in financial legislation, and especially the Bulgarian Labor Code protects reporting employees in case of report of financial market breaches. Then, of course, the Bulgarian Anti-Corruption Act, which also provides some measures to protect whistleblowers. As you may see, that the degree of protection in the European Union countries is different. In Bulgaria, it's even behind of that. Before continuing with the next slide, I just wanted to mention 2 words about countries which are located next to Bulgaria, which have very developed whistleblowing legislation. This is the case, for instance, with Romania and in particular Serbia and Hungary, which implemented such legislation for the public sector, and it resulted in a large number of prosecutions and in large number of prevented fraudulent situations. So it's something which exists already in the region. Now, what is to happen is that the European Union adopted a directive in 2019 on the protection of whistleblowers, of person who breaches European Union law. So member states will have a 2-year period until December 2021 to implement the respective provisions of the directive. However, from our experience in countries where such measures have been already adopted and where companies had already to comply with them, we establish a number of risks which arise for the business, so very practical risks which should be taken into consideration as soon as possible. The first major risk which we see is the abuse of rights by whistleblowers. As we'll see in the next slide, they will have very wide protection. So many people could be tempted to use the protection of whistleblowers in order to prevent, for instance, their dismissals or any disciplinary measures. The second risk is the reporting of false information with intention to harm employers or leaders' interests. This situation is very happening relatively often in bigger structures where people do not necessarily have the everyday interaction. And here will be the responsibility for the business to put in place internal systems how to filter this false information from the real issues. Then there is the risk of alleged false retaliation measures by employees and the risk of too large scope of the retaliation definition, leading to large possibilities of blackmailing employers, shareholders, or other partners in work-related activities. I'm speaking about this because a number of years ago, our law firm put in place an external service for our clients which has such obligation to provide whistleblowing solutions. So during the years, we acted as an external whistleblower system provider for a number of companies in different sectors, in the financial sector, in the construction sector, in the pharmaceutical sector, retail sector. And we have already some statistics outside of Bulgaria, of course, but also for some companies which have adopted voluntarily such systems in Bulgaria, of what are the issues. Now, who would actually be the whistleblower under the new directive and probably under the legislation which will be adopted by Bulgaria? The whistleblower would be first a working national person, which in a work-related context, has acquired information on breaches of the European Union law. Now, this is the very conservative definition of whistleblower. However, the European Union directive actually enlarges the scope of people, and we will see in the next slide, to much more people which are also non-employees, which are providers, etc. But the idea of the whistleblower is someone who has acquired some knowledge about breaches of the law. Now, in order to become a whistleblower, there is another important element to report these breaches, which can be done internally or externally, and we will see how. What exactly would mean working national person under the new European Union directive? First, those could be, of course, the workers, the civil servants, the person directly employed. They are in most of the cases the most common whistleblowers. Second, those could be persons which work under the supervision of contractors, subcontractors, and suppliers. And here you can see that this enlarges the scope of the people who can report any breach. This could be your contractors, for instance, a company which you have engaged for accounting, or a company which you have engaged for some consulting work. Then it could be self-employed, some self-employed external consultants. It could be a person on a work-based relationship which already has ended. So a whistleblower can be a former employee. Whistleblowers could be also shareholders, members of companies' bodies, volunteers, trainees. So any person which may happen to know some information of any breaches. Whistleblowers could be also facilitators. We know they exist in a number of fields. Could be colleagues or relatives of employees. So it could be, for instance, we had such a situation, the wife of a contractor heard about a potential breach, and she used the company whistleblower system to blow the whistle. And of course, those could be legal entities which are connected in a work relationship. So you see, basically everybody which has a touch to your business can be a whistleblower and can fall under the protection of the new directive. What the information for the breaches should contain? The directive puts a number of criteria in order to distinguish between whistleblowing information and any kind of other information, complaints, etc. The information should provide reasonable suspicion about actual potential breaches of the legislation of the European Union, which includes, of course, the treaties, the regulations, the directive, or of the national legislation which implements those rules. For instance, let's say public procurement, if there is a breach, information for breach of the Bulgarian Public Procurement Act, this could qualify. For instance, financial regulation, if there is a breach of the Bulgarian legislation implementing EU financial directives, again, this could fall into the scope. Then the information should be about a breach which occurred or it's very likely to occur, not about hypothetical breaches. It should be for the organization to which the whistleblower has any relation, and not just general complaints. As noted, the scope of the protected legislation is very wide. The European Union has chosen to include a very, very wide number of directives of its legislation. Now, also, as I mentioned, this will imply all the Bulgarian transposing legislation. And here comes a very important point where we'll see how Bulgaria will implement this. National legislators, so in Bulgaria, the parliament, will have the discretion to decide whether they would wish to extend the scope of the whistleblowing protection also to situation of breach of Bulgarian law. This is very major difference, and here it's important to see how the Bulgarian legislator will approach, because explicitly in the directive is stated that the states may have the freedom to allow this. Some states have already declared that they will extend this protection also to national legislation, and then of course we'll have many more grounds for whistleblowing, including, for instance, criminal law or administrative breaches on the local legislation. So this question will remain open. Now, what will stay out of scope of the directive and the protection of the whistleblowers? Of course, there's some sector-specific legislation which has even more fine-tuned whistleblower protection, and it will not apply to it. It will not apply to any national security or defense procurement rules. It would not apply to classified information. It would not apply to legal and medical privilege. At this point, it's very important, and here we'll see a new field of liability, but also a new field of opportunities for the legal profession, because the legal profession will not be involved in this whistleblower protection. So your law advisors, your legal advisors will not have the obligation, it will not have also the opportunity to blow the whistle about breaches in your companies. This will not apply to consultants, to auditors, to accountants. They will still have this obligation. So here it puts a very, very clear threshold about the privilege of the legal protection of the legal profession. Then, of course, judicial deliberations will not concern criminal procedures or national rules related to workers in their trade unions activity. Reporting will be protected in a number of ways. First, the whistleblowers will have to have reasonable grounds to believe that the information was true. This is a requirement which will be set the national legislation. Further, reporters should be sure that the reported breaches fall within the scope of the directives. And then they will have to choose the appropriate channel of reporting. And here comes the very important point for businesses. Legal entities will have the obligation to establish channels and procedures for internal reporting and follow-up. This will mean that companies will need to start relatively soon to think what would be the most appropriate channel for them to establish such a procedure. Similarly, member states will have to establish external reporting channels, which task will be to allow people which are not happy for some reasons with their internal whistleblowing to report directly to public authorities. Now, maybe some of your companies have already such whistleblowing internal systems. This applies in particular for international companies which are based in jurisdictions which require this, for instance, for public traded companies or companies operating in some sectors. Those are very good examples what would be expected from most of the business in 2021. And the European Union directive and hopefully Bulgarian legislation will provide different approaches how to deal with this. There will be the internal procedures where basically a company sets up its internal service which will deal with these whistleblower complaints, signals. The other option is to have an external provider, for instance, to agree with an external company, absolutely independent, which will collect, which will provide the IT infrastructure, and which will administer these complaints in the proper way. And perhaps for most businesses, this is the most cost efficient and most also compliant way to deal with this. And the third possibility for whistleblowers is, of course, to go to the public authorities, but only limited situation. Now, what we see in practice is that the most large international companies present in different jurisdictions are already implementing these systems in order to be prepared for the entry into force of the legislation, and not to be prepared, meaning to have the system, but in the meaning to have their teams, to have their internal functioning adapted, and to have an internal culture of understanding of the whistleblower rationale. So to be sure that their employees will not use in abusive manner of this system, but they will understand that this works for some specific situation, that this it's done to really blow a whistle about breaches of law and not just for internal complaints. Now, based on our experience with a number of companies in our jurisdictions, what we see is actually if such a whistleblowing solution is implemented, then it can really bring additional added value to the company, because it will allow the company to learn a lot of its internal issues, to learn a lot of its internal dysfunctionalities. So it's not only an obligation, a potential risk, but it's before all, it's a good opportunity for business to improve its internal organization. Finally, very shortly, I will just mention that the whistleblowers will have to be very, very strictly protected, and there will be a lot of provisions in this respect. There will be prohibition of any suspensions, demotion, withholding of promotions, transfer, coercion, intimidation, etc. But this will be rather interesting to see how the national legislator will apply this. As I see my time is over, I just wanted to focus that in order for such a system to be implemented in a compliant, in an efficient way, in order for such a system to bring value to your business, it should be done well in time. Our practical studies showed that whistleblowing systems start working at least after 1 year since their implementation, and the first signals that the culture of the firm understands, the employees understand what is the purpose of this system comes approximately between 18 and 20 months after the implementation. So the recommendation will be to start preparing for this as soon as possible. Thank you very much, and I will be staying online if any questions should arise.
Thank you very much, Oleg. We are running out of time, but happy to take one question, if any. Don't see anything in the chat, but you have Oleg's email from the presentation, so you can ask your questions after that. Thanks again, Oleg, for this interesting presentation. And now I suggest we move to the next one. I would like to invite Adelina and Christo from Deloitte to talk about the new EBA outsourcing guidelines. Adelina and Christo, who will start first, so you can get the mouse?
So thank you very much. Hi, everyone. I'm Adelina Mitkova, manager at Deloitte Legal Law Firm. In the next few slides and 15 to 20 minutes, I and my colleague Christo Milushev will briefly tell you about the new outsourcing guidelines of the European Banking Authority, or the EBA in short. Actually, the guidelines are not new. Guidelines on the topic have been in place since 2006. We all see that in the last few years, financial institutions are more and more interested in outsourcing business activities in order to reduce costs, improve their efficiency, and be more flexible. In the context of the rapid digitalization and the increasing importance of IT and financial technologies, financial institutions are adapting their business models, processes, and systems to embrace new technologies and to achieve economics of scale. Notwithstanding the benefits, outsourcing poses security issues and challenges to the governance framework of institutions, in particular to internal controls as well as to data management and data protection. Outsourcing of critical or important functions creates specific risks for both institutions and for their competent authorities. This is why outsourcing should be subject to appropriate oversight. In this regard, the EBA decided to issue an updated version of the guidelines. The aim is to address the changes and to set a harmonized framework for the outsourcing arrangements of all financial institutions that are within the mandate of the EBA. The new guidelines incorporate also the recommendations on outsourcing to cloud service providers, which were published in 2017. The guidelines were published in February 2019. They came into force a few months later and apply to all outsourcing arrangements that are concluded or revised after September 2019. The institutions will have until the end of next year to update the existing outsourcing arrangements. If the review of the outsourcing arrangements for critical or important function is not completed by the end of year 2021, the institutions should inform their competent authorities and should report on the measures they intend to take in order to complete the review or the possible exit strategies. The old guidelines applied exclusively to credit institutions. The scope of the revised guidelines, however, is expanded and they affect not only credit institutions, but also investment firms, payment institutions, and electronic money providers. Indirectly, they apply to service providers of the outsourced function, as they have to pass the required assessments and due diligence processes on the part of the outsourcing institution. The guidelines apply to all outsourced functions, including activities that require authorization by a competent authority. They apply both to intragroup and external outsourcing arrangements. The institutions have to consider various risks related to intragroup outsourcing, including whether there is risk of conflict of interests. There are additional requirements when institutions outsource functions to providers from third countries outside of the EU. One of the key rules is that the institution may not delegate liability to the service provider. Outsourcing must not lead to a situation where the institution becomes an empty shell that lacks substance to remain authorized. To this end, the management must ensure that sufficient resources are available to appropriately support and ensure the performance of its responsibilities, including the oversight of risks and management of the active outsourcing arrangements. All requirements set out in the guidelines are subject to another key principle, namely the principle of proportionality. In other words, the guidelines should apply in an appropriate way, taking into account the size, the internal structure, the nature, scope, and complexity of the activities of the institution. You can see on the slides some of the main topics that the institution should consider when applying the requirements. We are going to talk about some of them in more details in a few minutes, including about what is considered an outsourced function, what are the criteria to distinguish critical or important function from other outsourced functions. We will also touch base on the requirements that apply to the outsourcing policy, the outsourcing agreements, and the outsourcing register that institutions have to maintain. There are also other requirements which we are not going to discuss in details, but are important and have to be considered by the institutions. For example, according to the guidelines, it is crucial for the institutions to conduct appropriate due diligence on the service providers before entering to outsourcing arrangement in order to check if the service provider is suitable. Also, institutions must implement effective management, control and supervision mechanisms of outsourcing processes, which they should apply on a daily basis. Further, there are rules on sub-outsourcing, which are stricter if the function is critical or important. Another thing that institutions should consider, although not required by the guidelines, is for each institution to decide how to structure the function of an outsourcing officer, whether this should be a new role, a new division, or existing roles and divisions will take on the functions and thus have to be reorganized. This will depend on the size and complexity of the activities of the institution. So, what is outsourcing according to the guidelines? The definition is very broad and in practice covers any type of arrangement between an institution and a service provider by which that provider performs a process, a service, or an activity that would otherwise be undertaken by the institution itself. If in the assessment process, institutions should consider whether the function is performed on a recurrent or ongoing basis by the service provider, and whether this function would or could normally and realistically be performed by the institution, even if the institution has not performed it in the past itself. Therefore, we think that one-time functions should be out of scope. The guidelines contain an exemplary list of functions that are usually not considered as outsourcing, like a function that is legally required to be performed by the service provider, such as statutory audit, global network infrastructures like the ones operated by Visa and MasterCard, clearing and settlement arrangements between clearing houses and CCPs, corresponding banking services, and others. Once it is clear whether there is outsourcing or not, according to the guidelines, we have to assess whether the function is critical or important or not. As already mentioned, there are stricter rules for the functions that are critical or important. The guidelines contain quite complex rules for the assessment, which are not straightforward, and so we think in practice they will cause a lot of problems. We do not have much time, and I will touch base briefly on the criteria. In the Q&A session or after the webinar, of course, we could discuss in more details if you like. According to the guidelines, institutions should always consider a function as critical or important in certain situations listed in the guidelines. For example, where a defect or failure to perform the outsourced function impairs compliance with the license of the institution or its financial performance, or the soundness of the banking and payment services activities. You see that this one is very broad. The guidelines list additional risk factors that have to be taken into account, including whether there is a direct connection of the outsourced function to activities subject to authorization, the impact of any disruption or failure of the provider to perform at the required level on the business continuity of the institution, the impact of the outsourcing arrangement on the ability of the institution to manage various risks, to comply with regulatory requirements, and to conduct appropriate audits. Other risk factors institutions have to consider include operational risk, legal risk, reputational risk, impact on the services provided to the customers, ability to transfer the function to another provider, or to reintegrate the function back, and others. A clear example for critical function is, of course, the core banking activity, which requires a license. Now I give the floor to my colleague, Christo.
So the requirements under the guidelines fall into two categories, broadly speaking. On the one hand, governance requirements, which pertain to an institution's preparedness to enter into advantage outsourcing arrangements. And these include the maintenance of a written outsourcing policy, a written outsourcing register, measures regarding conflicts of interest, business continuity, audits, and so on and so forth. On the other hand, the process requirements, which mandate specific steps to be undertaken on a proposal those outsourcing arrangements. And these include due diligence, duty to inform, contractual requirements, etc. Now, institutions and payment institutions and management bodies in particular have a general obligation with guidelines to prepare, regularly review, and update the written outsourcing policy. So what is new here? Well, quite a bit actually. The outsourcing policy must cover all the ground, including the responsibilities of the management body, including its involvement in the decision-making and outsourcing of critical important functions, the involvement of various business lines and internal control functions with outsourcing arrangements, the planning of outsourcing arrangements, implementation and monitoring and management of outsourcing arrangements, documentation and record keeping, and finally exit strategies and termination processes. The planning part of the policy is where most of the novelties can be seen. And those include criteria and processes for the identification of critical and important functions, the approval process for the outsourcing arrangements, the due diligence of prospective outsourcing service providers, and also ongoing assessment of the performance of the service providers, which the institution or payment institution works. This is continuity planning regarding critical and important functions, process for mitigation of conflicts of interest, procedures for being notified regarding changes to an outsourcing agreement, or the service provider thereafter. These are fairly broadly and generally described, and therefore it is up to institutions and payment institutions to put in the specific and therefore balance compliance with the outsourcing guidelines on one hand and their regular approach to day-to-day business. Register of outsourcing activities. Now, under the updated guidelines, institutions and payment institutions are required to maintain a written register, which includes information on all existing outsourcing arrangements, including the basic information regarding contracts, including start date, next contractual renewal date, date of expiry, a brief description of the outsourced function, information on the outsourcing service provider, including name, corporate registration number, address, contact details, and where possible the name of the parent company of the outsourcing service provider. The register must also include the country where the outsourcing service is to be performed, whether the outsourced function is considered critical or important and why, the date of the most recent assessment of the criticality or importance of the outsourced function. And in case of outsourcing to a cloud service provider, the register must contain information on the cloud service and deployment modes, specific nature of the data to be held in the locations where that data will be stored. Now, there are additional more detailed rules for critical and important functions. The register should include even more information, including institutions or payment institutions within the corporate group make use of the outsourcing service, whether or not the service provider is part of the corporate group, the date of the most recent risk assessment and a brief summary of its results, the individual or decision-making body in the institution or payment institution that approved the outsourcing arrangement, the governing law of the outsourcing arrangement, the dates of the most recent and next scheduled audits, names of subcontracts, where applicable. They must also include the outcome and the assessment of the service provider's substitutability, which is graded at 3 levels: easy, difficult, and impossible. And that relation, they must identify possible alternative service providers.
If you have any questions to Christo and Adelina, maybe if you could just answer through Adelina's microphone. I don't see any questions in the Q&A section, but apologies to the attendees for the technical glitch with the sound. You see Adelina's and Christo's contact details. It was an interesting presentation, really a pity that we couldn't hear almost anything from the second part. questions to Adelina and Christo, or should we move on? Okay, I suggest we move on, and hopefully we will hear our next speaker well. Georgi, if you could bring back the key slide. Yes, thank you. So now the next presentation will move away a little bit from the legal and regulatory aspects. I would like to invite Evgeny Penev from Maconis, who will tell us about the Eurozone waiting room, entering and the macroeconomic risks for Bulgaria. And Evgeny promised also to reshape his presentation to take into consideration the current new situation around COVID-19. Evgeny, the floor is yours. Just scroll down for the next slide. Thank you.
Can I first ask how many people are attending right now? Do we know?
About 40 people on the line now.
Okay, great. Thank you very much. My name is Evgeny Penev. I'm managing partner of Maconis LLC. Maconis is a investment boutique, advisory boutique, since 2007 on the Bulgarian market. About the same time, I've been also working for the Big Four. So over 20 years, I've been doing M&A advisory and corporate finance advisory. So I have the honor now to present to you the latest developments with the Bulgaria entering the waiting room of the Eurozone, so-called exchange rate mechanism 2. It was the hottest topic perhaps in February, until actually the COVID-19 took over all the media attention. At any rate, I will touch on the macroeconomic risk of COVID at the end of the presentation. I just want to now shortly go through the major topics and issues concerning our participation in the waiting room. So, can we move to the next one? Just in brief, first of all, we'd like to go through the major milestones, including the Maastricht criteria for joining the Eurozone, what commitments Bulgaria has taken before to enter the waiting room, the major amendments to laws that have taken already place, including the one in the BNB law. And at the end, I will finish up with the macroeconomic analysis for Bulgaria and whether we could rely or could expect actually entering the room this year or not. So shortly, you see in front of you now what was the road so far of European integration of Bulgaria. I would like to focus here on two major points that you wouldn't quite well see on the this timeline. First of all, very few people remember, or at least the media actually skipped the issue of the condition under which Bulgaria actually was joined the European Union on January 1st, 2007. And this is actually a 3-year cooperation and verification mechanism to check whether Bulgaria progresses with regards to one of the Copenhagen criteria that Bulgaria didn't meet at the time of its accession, namely the application of rule of law and combat of organized crime. This mechanism, now 12 years later, is still in place, although now there is some rumors that it will be lifted, but it's not quite clear whether this will be the case. I'm emphasizing on this because although this might not be an issue when entering the waiting room, this might become a big issue for joining the Eurozone laterwards. Another point, another milestone that you don't see here is our joining of Schengen. This was not successful so far. And if you imagine a house of the European Union, it has different floors. Now we are just on the first floor. This is actually simply the entrance to the European Union. The second floor would be meeting the Copenhagen criteria of rule of law. The third floor perhaps would be the Schengen zone. And the fourth floor would be actually the Eurozone. So you see that even though we might be able to join this year, which is now under question given the outbreak of the virus, we have still a long way to go being in the waiting room to meet all these criteria in order to join the Eurozone. Okay, can you go further on, please? So just want to point out what the Maastricht criteria for Eurozone accession are, that the European Commission is monitoring, and so is the European Central Bank. So right now, until last year, we were meeting all the criteria. However, at the end of 2019, the inflation that we had for last year was 3.1%, which is exceeding the reference value. Although this reference value is also 1.9%, it's also changing. It's based on the average of the lowest three inflation rates in the European Union, sorry, the Eurozone, plus 1.5 percentage points. But obviously we have exceeded this for last year, although this should not be a problem for the time being to enter the waiting room. I will come back to this slide at the end when we discuss the macroeconomic risks. Please go on. So the major milestones, first, well, Bulgaria, there was a joint letter of the Minister of Finance and the Governor of the Bulgarian National Bank in July 2018, where we expressed our interest to join the waiting room. The exchange rate, this is actually the exchange rate mechanism too. As you might know, Bulgaria is the first country that actually has to meet another criteria that the other countries in the Eurozone have not met before, because the banking union was not existent at that point. We have to also join the banking union simultaneously before entering the exchange rate mechanism. And this was a precondition, because one of the biggest problems Bulgaria has for joining the waiting room is with its banks. First of all, until last year, we were exceeding the average of percentage of bad loans of our banks, of our banking system. Now there is a very positive report that this imbalance was corrected, and we are already about the average of 7%. However, we do not have, we have not met yet to one of the problems that was discovered during the stress test. The European Central Bank, under its patronage, so to speak, was carried out in Bulgaria. And this is namely the two banks, First Investment Bank and Invest Bank, that actually have problems with their capital adequacy. And they have taken obligation until end of April to meet this criteria. This was the reason why Bulgaria wouldn't join in April as it was planned, and it was rescheduled for July as of late of February. Now, of course, nobody has postponed this deadline or planned deadline for end of July, but probably, given the current situation, it will be postponed again. Nobody would really know when exactly we'll be joining the waiting room now. So the commitments Can you please go to the next? Thank you. There are many commitments that Bulgaria had taken in order to meet the preconditions to enter the exchange rate mechanisms. First of all, regards to the banking union, and I'll talk about a little bit more about this later. We had to carry on a major recall, so to speak, or major change amendments to the law on credit institutions in Bulgaria, with the main purpose to expand the sanctioning role of BNB and also to allow BNB to so to speak, to introduce and to exercise the influence of the European Central Bank over our banking system. This is very important because until recently, European Central Bank could only actually provide advice, but not any really sanctioning power. Now this is a fact. In a moment, I'll come back to the issue with the change of the BNB law, because this is very important as it provided or provoked a big scandal in Bulgaria. As you see here, there are many laws that were supposed to be changed in order for Bulgaria to meet the preconditions for entering the waiting room. Here we're talking about developing macroprudential supervision, talking about the change of the supervision framework in the non-banking sector, improving the insolvency framework, especially the banking system, changing the anti-money laundering framework. This was again a little bit providing discontent among certain circles in Bulgaria because it provided the authorities with extra power. Also, another very good point was the modernization of the framework of state-owned enterprises in line with the good international practices, which was pointed out in their winter semester report of the European Commission. And of course, this was, I think, done back in 2018. There was a law ratifying the agreement on the transfer and mutualization of contributions to the Single Resolution Fund. This is the fund actually for restructuring of the banks that are under insolvency. Can we go on? This is actually the amendment to the BNB law that provided big debates or provoked big debates in Bulgaria. There are still people now claiming that Bulgaria is not in a currency board any longer because of this change in this law. However, whoever reads carefully what the amendment is, you will see that this amendment relates to the time when Bulgaria is already in the waiting room, not before entering in the waiting room. And simply, this was part of the European legislation, and this legislation was passed without taking into account that there will be future candidate members with the currency board. That's why the amendment wanted to check out whether Bulgaria could keep the rate within 15% borders of fluctuation during the time while it's in the waiting room. However, there is no problem whatsoever. This was the cases of the Baltic republics that were under some currency board or similar arrangements. All of them were in the waiting room with a fixed rate. So there is no problem whatsoever that Bulgaria would keep its rate to the euro while in the waiting room. Okay, can we go on? So, however, all the things are changing now, And this would perhaps postpone once again, maybe for the third or fourth time, the time that was scheduled for Bulgaria to enter the exchange rate mechanism too. The COVID-19 disease actually has generated big risks, enormous risks, say, for the macroeconomic stability, not only of Bulgaria, but the whole world. Bulgaria just met with this report that I mentioned for the winter semester, the European Commission, it actually had no imbalances whatsoever. And we were really well positioned to enter the waiting room. However, now with the new situation, it's very possible that there will be some serious problems with our macroeconomic stability. In the first place, this probably would affect the budget deficit that would run over 3%, which is over the limits of the Maastricht Treaty. Another one, as I said, we just covered the average European ratio of 7% bad loans. And it's very probable that, again, the bad loans would soar, given the new government policy also to push the banks to lend loans to the private sector under alleviated terms. Another very serious issue would be the trade balance of Bulgaria. As you might know, the exports provide about 2/3 of the GDP. And it's expected that the exports would be very seriously affected now with the current situation. However, with regards to the Maastricht criteria, I just want to make sure that, can we just go straight in the beginning? Yes, here. No, this, the one that you just, okay, here. As you see here, the 5 criteria, it's very likely that the inflation will go down. Actually, there will be perhaps deflation due to the very low consumer demand now in this situation. The interest rates are down anyway because of the low demand. The public debt perhaps will go up. However, we are way below the 60% of GDP that is the Maastricht criteria. And the only serious criteria that perhaps we will not meet will be the budget balance. Can we go back, please? Okay. Now the situation, without being sound tragically or dramatically, is very, very serious because the most affected industries, on one hand, we have the domestic industries of trade, tourism, which is not strictly domestic, but business is conducted in Bulgaria. And also, of course, you have the trade, tourism, transport, on one hand, and on the other hand, you have the big enterprises that are part of international supply chains, like, for example, the auto parts, that we have more than 50 plants in Bulgaria that are producing auto parts. Already we hear about some of them closing. All these sectors that I just enumerated so far, providing about 40% of GDP. So you might imagine what would be the effects of closures here for the unemployment and social stability, because many of them are in the countryside and there is no alternative source of employment. So this could impact, well, the demographic situation in the country. It could be enforced immigration, especially if there are no jobs enough in order to keep the people in Bulgaria. So the situation is very, very serious. How about the government support to the private sector? I'm afraid that it's neither adequate, nor the scale is enough, nor it's really timely. In the sense that, as opposed to other countries, we are only supporting the private sector through loans and the support for the. Of course, there's some postponement of deadlines of taxes, but this, I don't think this is a huge help at present. But just pay attention that we are providing support to the private sector in the size of 60% of the social security income. And this is well below the 80% that, for example, Czech Republic is providing, and Britain, 75% of Denmark is providing, and also based on the salary, not based on the social security income. Besides the scale, they're providing almost to all the private sector, whereas our help is very conditional to limited sectors. For the scale, I just could tell you that, for example, United States, the envisaged measures about 10% of GDP. In Denmark, about 30% of GDP. The claimed support of the government, about 4.5 billion leva, is about 3% of GDP. And you have to take into account that big chunk of this support is going back to the government in the form of taxes and social security for the all businesses that keep their labor. That's why there is a huge discontent right now within the private sector about these measures. Also, of course, the measures look timely, but some of the measures actually are based on meeting certain criteria over time, which means that they're not really timely in this sense. And of course, it's very, very important what the international political business environment will be in 2020, because now this is a precedent. The whole economy, world economy is being stuck, and nobody really knows what the macroeconomic effects would be worldwide, including on Bulgaria. As I already mentioned, about 2/3 of our GDP is represent exports. We don't know what the situation would be now with these exports. Also, investments and capex was very low anyway before the crisis. Now, perhaps it will be even close to zero. Capital inflows that are very, very important for our economic growth. And of course, if we go to the international markets to look for new debt, we don't know what the cost of funding would be now. The international price of our debt went lower in the last 2 weeks. That means the cost of the funding went up. This is a very serious issue because this would be a bigger burden on our budget for repayment of interest. And last but not least, as I said, there will be huge social unrest, perhaps later part of the second part of the year, that would also could provide unknown for the time being political and social impact on our economy and society. Thank you for your attention, and I hope I get some questions to answer.
Thank you very much, Evgeny. Just on the last point on the government support to the business, I would like to point out that yesterday we distributed a survey to all members of BBBA, asking them for their feedback on what kind of measures they would like the government to take in order to support the business in these difficult times. The deadline is end of the day today, because we are in a hurry to coordinate our efforts with 10 other international chambers in Bulgaria, so we can have a stronger voice together. So please kindly fill in the survey today so we can continue with our efforts in the next days, and hopefully the grim picture that Evgeny painted in his last slide could be somehow alleviated. And I would like to thank Evgeny in particular for helping us with the survey and also with sharing his economical updates and comments from the last few days regarding the changing situation. I don't see any questions in the Q&A. You saw Evgeny's email, and we will also share the contacts of all speakers with the attendees. So we will have the chance to ask your questions later. Now, as we are running a little bit ahead of time, I would like to invite Dima to talk about mediation. Dima, Georgi has already uploaded your presentation and we'll pass the mouse to you now. So all you have to do is to scroll down to your slides.
Hello, everyone. My name is Dima Alexandrova. I'm Bulgarian qualified lawyer and mediator. I'm running my own practice under the brand name of Dima Law for 2 years now. And in the next 15 minutes, I'll present to you the topic mediation as an effective ADR tool. ADR stands for Alternative Dispute Resolution. Why I chose this topic for the tax and business regulatory update of the BBBA? First, because I believe it's rather new for Bulgaria, even though there is a law of mediation since 2004, mediation still is a pretty new procedure for Bulgaria. And moreover, there is news with regards to projects to make it compulsory in Bulgaria. So I believe it's also important to be talked about. And finally, mediation is a business-friendly procedure. Thus, it should have its place in the business and tax regulatory update, in my opinion. In the presentation, I will follow the following structure. First, I'll give you my own definition of mediation. Then I'll talk a little bit about mediation in the situation of COVID-19. And then I will expand on the advantages of mediation, first as compared to court trials, then as compared to negotiation. And finally, I will end up with talking about mediation development in Bulgaria, in the EU, and in the world. So should you have some questions, please feel free to ask them via the Q&A section. So what is mediation? Mediation is an innovative procedure which facilitates achieving business-friendly solutions in a time and cost-effective manner. Mediation is the closest to the real business ADR tool since it enables the very business decision makers to decide their dispute on their own, considering all business and other aspects they need to, and resolve the dispute led by their own sense of fairness and resorting to a reasonable solution to live with. The parties are held by the lawyers they personally trust, and they have the guarantee that the very same lawyers will draft the final resolution. So I believe that this is a definition which really suits the business. Why mediation in a situation of COVID-19? We all know that this is a pretty challenging situation where a lot of conflicts can be triggered by the instability, uncertainty, and panic. So I believe that mediation can play a really positive role when it comes to preventing and also amicably resolving these disputes. Furthermore, the courts are closed down now, so we can maybe try to use some innovative procedures such as mediation in order to try to resolve our disputes when we are somewhat precluded from justice in the courts. And also the principles of mediation about collaboration and mutual gain are pretty useful when it comes to such a difficult situation when we have the COVID-19. Mediation also helps in brainstorming unusual solutions in difficult situations, so this can also be used. Examples when we can use mediation right now is, for instance, when we resolve disputes between shareholders, for instance, or when we have intense negotiation settings to reduce the pressure and achieve productive dialogue. Mediation can be held online, just like now via Zoom or some other mediation platforms. So if you feel like mediating, please do consider that. So now about the advantages of mediation. The first and foremost advantage of mediation, in my opinion, is the fact who makes the decisions in mediation. The mediations are done by the parties of the dispute themselves. Unlike the other procedures where we have either a judge or an arbitrator imposing a decision on the parties, we have here only a mediator who facilitates a dialogue between the parties, and he provides a third-party neutral perspective. This is also a difference that we have with the ordinary negotiation procedure, where we don't have a third-party neutral perspective and we don't have a third party facilitating the dialogue. In practice, it's really useful, and it's really difficult to be explained in words, but having a third-party neutral when we negotiate, it's really useful. So this makes a big difference between mediation and negotiation. Scope of mediation. What is really good about mediation is that it can go far beyond the legal dispute, and it also appropriate for disputes where the legal terms preclude the option to file a claim, where the prescription period has passed, for instance, but we still have the need to resolve a dispute, and it's no longer legal dispute actually. Mediation is also appropriate, in my opinion, for spheres where the legal development is behind the relationships that are regulated, or in other words, where the regulated relationships override the legal development. Another advantage of mediation is the forward thinking or the future oriented thinking. Mediation is not about who is right or who is wrong. The aim is to find a solution to live with. All procedures, all other ADR procedures such as arbitration and also the court trials are past oriented. We discuss what happened, while in mediation we discuss what could happen right now, and we can only define the future. That's why I believe that mediation can be useful when we talk about the future. Another advantage of mediation is the fact that it offers a balanced agreement. The presence of the mediator assures that the true interests of the parties will be uncovered and will be further balanced in the aim to achieve a mutually beneficial solution. Unlike ordinary negotiations where there is a battle of interests, in mediation the mediator ascertains that the balance is maintained, which guarantees the agreement will last. The mediator assures a neutral service to both parties, and in this way they receive an equal protection of their business interests. The mediator equally examines the business interests of the parties in the aim to lay the foundations of a stable agreement. And also, I believe that mediation is really useful when it comes to having different positions of the parties in dispute. When we have a mediation, there is no economic inequality between them because they have the chance to have the same mediator. While if we have a court trial or an arbitration procedure, we have different access to legal defense, or at least different resources of the two parties. When it comes to time and money, mediation can be really effective. It is cost effective and time effective since the solution can be reached in a couple of meetings. And if we find it necessary, it can be approved by the court under Article 18 of the Law on Mediation. Another advantage of mediation is the fact that we select the lawyers that write the final agreement. In mediation, the lawyers that the parties have selected draft the final document, unlike the procedures in court, for instance, where we have a judge who we haven't chosen to write the final act, which is imposed on the parties. And I believe that it is beneficial both for lawyers and both for the parties, because first, the parties choose the lawyers they trust in. Second, these are lawyers who are highly specialized in the area of the dispute. So this is a really rare opportunity in the court or even in arbitration. When it comes to risk, in mediation, there is no risk of losing because this risk is completely mitigated since it's a win-win procedure. We are looking for a win-win solution, and there is no risk to lose a case. So I believe that this is good both for parties and for lawyers, because as a lawyer, I cannot guarantee my clients that we will win a case, but in a mediation procedure, we have higher control on the outcome of the procedure. So mediation development in Bulgaria, in general, I would say that there is a lot of room for improvement in mediation development in Bulgaria, even though there is a law since 2004, and there is one ordinance dated the 15th of March 2007. They both regulate the way we exercise the mediation profession in Bulgaria, and also the law has some provisions on the legal force of the mediation settlement. So I would like to cite it. The mediation agreement has the legal force of a court settlement and is subject to approval by the court pursuant to Article 18 of the law on mediation. And it's also important that no prescription periods run in the course of mediation. What is new about mediation development in Bulgaria is that there are projects to make it mandatory, just like in Italy and some other countries in Europe. What does mandatory mediation mean? And can a voluntary procedure as mediation be mandatory? Actually, we are talking about a mandatory first meeting about mediation. It is a meeting where the parties meet with the mediator, they exchange their points of view, they also understand what mediation is and what they could do if they proceed with the mediation procedure. But it's finally up to them whether to continue with the mediation or not. So the mediation still keeps its voluntary nature. The scope of mandatory mediation will probably be family disputes and tort and contractual disputes up to 5,000 Bulgarian level. At EU level, there is a directive on certain aspects of mediation in civil and commercial matters that we have transposed in the law that I just cited. And now I would like to expand on the Singapore Convention and the law development of mediation. So what happened last year on 7th of August was that the Singapore Convention was open for signature, and this convention will enter into force on the 12th of September 2020. Unfortunately, Bulgaria is not a part of the convention, but what is really important about the convention is that it provides a process for direct enforcement of cross-border settlement agreements between parties resulting from mediation. The convention provides that a settlement agreement may be enforced directly by the courts of a state, and this allows the parties seeking enforcement to apply directly to the courts of a state where the assets are located, such that execution may also be sought if the enforcement process is successful. And this prevents potential multiple proceedings. The Singapore Convention is an equivalent of the New York Convention for arbitration awards. And I believe that it's important that Bulgaria becomes a party to it because it will further boost the business options we have. I have written an article in the Capital newsletter last year about the Singapore Convention. So if you're interested about more aspects of it, I could provide you with the article. And finally, in order to have the settlement, the mediation settlement enforced, it should be in writing. It should result from a mediation. It should be agreement between two or more parties who have their place of business in different states. And the place of business of each of the parties to the agreement is in a state that has acceded or ratified the convention. So I would like to thank you for your attention. If you have some questions, please feel free to ask them.
Thank you very much, Dima, for the interesting presentation on mediation, a tool that I personally find very useful for resolving disputes. I don't see any questions in the Q&A section. Our audience is very quiet, literally. But I'm sure if somebody has a question, they can send it to you as well as to the other speakers over the email or in a private conversation. So now, last but not least, I would like to invite our last speaker, Alexander Hadjidimov. Alexander, my colleague Georgi will move to your presentation and will provide you with the mouse. Thank you very much, and good luck.
Thank you, Desi. Hello, everyone. I hope you hear me well. First of all, let me thank you to all of you who managed to stay tuned until the last session of today's webinar. My name is Alexander Hadjidimov, and I'm a director in the tax M&A team of KPMG in Bulgaria. I'm sure that most of you have already heard the abbreviations DAX6 or MDR in one context or another. And some of you may think that this is something that only tax advisors, consultants, accountants, lawyers, or other professional service providers should worry about. So in the next, hopefully 15 minutes, I'll try to show you that to a certain extent you might be right, but this is not always the case. The mandatory disclosure rules are important not only for consultants and advisors, but also for their clients. In a nutshell, we'll try to give some basic answers to the questions. What is to be reported, who is obliged to report, and when it should be reported. I will start with a very brief background on DAX6 and what is it in a nutshell. This is actually the latest, for the time being, amendment to the Directive on Administrative Cooperation in the field of taxation, which was initially adopted in February 2011 with the purpose of enhancing the administrative cooperation between the EU member states. I'm not going to focus on the various previous amendments to the directive, basically the idea of DAX6 is to improve the functioning of the internal market by discouraging the use of aggressive cross-border tax planning arrangements. Therefore, DAX6 generally introduces the obligation for disclosure of potentially aggressive tax planning arrangements on one hand, and the means for tax administrations to exchange information for such type of arrangements on the other. In general, the directive applies in the area of direct taxation, and therefore the scope of DAX6 covers all taxes except for VAT, customs, and excise duties, and compulsory social contributions. We will put more focus on what cross-border tax arrangement is and what specific criteria should be fulfilled, so that such an arrangement qualifies as a reportable one shortly. Can we go on the next slide, please? Here you see the timeline of the process of adopting the directive and its implementation in the domestic laws. I'm not going to focus on each of the dates shown on this timeline. From today's perspective, the different member states have reached different level of readiness on the implementation of DAX6 provisions in their internal legislation. Generally, they had the deadline for the end of December 2019 was the deadline for implementation in the local legislation of the EU member states. Some of them have done this, some of them are still in the process of doing this. And in January this year, the Commission initiated some infringement procedures against some of the EU member countries for their failure to implement DAX6 provisions on time. I know that most of them are currently progressing on this, but given the dramatic changes that occurred in the last month or 2 months and the corona pandemic may have impacts also on the possibilities of these countries to focus on the implementation of DAC 6. However, progress is being made, and despite the difficult situation. As it concerns Bulgaria, the provisions of the directive were transposed with the amendments to the Bulgarian Tax and Social Procedure Code, which were published on 31st of December 2019. And in general, the implementation in Bulgaria follows the scope and the logic of the directive, and there is no extension of the scope of the rules to taxes different from those to which the directive applies. And there is no extension of the scope to cover also domestic transaction, as this is the case, for example, with Poland. According to the provisions of both DAC 6 and the Tax Procedure Code, the Bulgarian Tax Procedure Code, the disclosure rule shall become applicable as the 1st of July 2020, with the first filing deadline being the end of August 2020. In the last couple of days, however, and due to unprecedented situation in different member states, rumors start spreading that the governments may consider extending the crisis-related measures also to some aspects of the implementation of DAC 6, either through extending the deadlines for the rules becoming applicable, or by extending the deadlines for the first filing. However, as of today, I'm not aware of any particular country having undertaken any tangible steps with this regard. And the recently adopted Act on the Measures in the state of emergency, there are no indications for extensions of the reporting deadlines in Bulgaria either. So I promised you to give you an answer of 3 questions. So the first question is, what is a cross-border tax arrangement? Can we go on the next slide, please? The definition of a cross-border tax arrangement as provided for by the Tax Procedure Code is quite wide and broadly defined to include any arrangement, contract, deal, agreement, plan, transaction, or series thereof, which concerns more than one member state or a member state and a third country, and may consist of more than one part or a step. In addition, there are 5 additional conditions which should be fulfilled for the arrangement in order to qualify as a cross-border tax arrangement. I'm not going to deeply elaborate on each of these conditions. You see them on the slide. Now, when we have defined what is the cross-border tax arrangement, we should probably focus on what is a reportable cross-border tax arrangement. Can we go on the next slide? The categories for a particular cross-border tax arrangements to qualify as a reportable one, it generally should fall into at least one of a number of categories, or using the terminology of DAC 6, it should fall within one of the hallmarks. The hallmarks are quite specific, and they address specific areas. I'm not going to read out loud all these hallmarks or categories. I would just limit myself to outlining the key groups in which they are grouped, can be grouped. This is what the directive did in the appendix to the directive. The Bulgarian law does not make such a grouping, but overall the same logic is followed in the Bulgarian law as well. So First, we have the general hallmarks linked to the main benefit test. We have some specific hallmarks linked to the main benefit test. The hallmarks related to cross-border transactions, where part of these hallmarks concern only transactions between associated companies. The fourth category is the hallmarks concerning automatic exchange of information and beneficial ownership. And the fifth and the last category is the hallmarks concerning transfer pricing. A statement which I quite often hear from clients is that, for example, okay, none of our related party transactions fall into any of the hallmarks, and so we are on the safe side from MDR perspective. It is important to be mentioned that, as a general rule, the potentially reportable cross-border arrangements need necessarily to involve only related parties. Thus, it is perfectly well possible that a cross-border tax arrangement may be put in place between unrelated parties, and it may still qualify as a reportable one if it falls into a particular category or hallmark. Still, there are certain hallmarks which are explicitly targeting arrangements between associated enterprises. This is actually the third category which I mentioned earlier. It should be noted that for the purposes of the MDR provisions, the Bulgarian tax procedure code as well as the directive itself introduce their own definition of associated enterprises, which I'm not going to deeply elaborate right now on this. The overall impression and feeling is that the hallmarks appear broadly defined so that they can cover as much hypothesis as possible. Based on discussions with colleagues from the KPMG network, I know that some of the countries and respective tax authorities there have prepared or are in the process of preparation of clarifications and guidance on the application of the mandatory disclosure rules. So far, and based on the information I have, the Bulgarian revenue authorities do not intend to issue a comprehensive set of guidance or interpretations of the different hallmarks and the specific types of cross-border arrangements potentially qualifying as reportable ones. Given the above, and a situation cannot be excluded that one and the same arrangement may be differently viewed and interpreted from the perspective of the various jurisdictions involved. And therefore, it would be important that the interpretation of the different jurisdictions involved is considered when potential for reporting obligations arising is being assessed. I think you have noticed that when making reference to the first two groups of hallmarks, both of them refer to link to the main benefit test. Can we go on the next slide, please? The main benefit test is an additional criteria which should be fulfilled for some of the hallmarks. In general, the main benefit test is considered fulfilled when it can be established that the main benefit, or one of the main benefits which have in regard to all relevant facts and circumstances a taxpayer may reasonably expect to derive from the cross-border tax arrangement, is the obtaining of a tax advantage. This reading of the definition of the main benefit test shows that this test does not focus on whether the obtaining of the tax advantage was the purpose or the main or one of the main goals of the arrangement or not, but rather whether or not a tax advantage may be expected to arise of as a result of the arrangement. And in order to make the issue even more complex, the Bulgarian Tax Procedure Code introduces its own definition of what is a tax advantage. The directive does not provide for such a definition. You can see the definition on your screens, and I would say it is also quite broad, and it covers not only undue tax advantages or tax advantages in excess of those that are due as potential indicators for aggressive tax planning arrangements, but also include tax advantages which are generally consistent with the principle and policy objectives of the applicable law. Therefore, the way how the main benefit test and the term tax advantage are defined is also another aspect which is left to each member state to decide on. And thus, attention should be drawn from the perspective of each jurisdiction involved. For example, as far as I am aware, in Germany, the German Ministry of Finance is authorized to issue a so-called white list of arrangements where no tax advantage is to be assumed, and arrangements that are included in this list are not required to be reported. So different countries undertake different approaches, and also with regard to the interpretation and application of the main benefit test, which is another area where difference in the interpretation and application of the directive may arise in the different countries. Now we reached one of the key questions, and this is who has the obligation to report? Can we move on the next slide, please? The short answer to the question is that depending on the circumstances, anyone may have the obligation to report. As a general rule, the obligation to report is for the consultants. DAX 6 refers them to as intermediaries, but regardless of the terminology used, these are the persons which are referred to as the ones with primary obligation for reporting. Between the consultants, there could be an additional split or classification be made between primary consultants and secondary consultants. The primary one being those who design, market, organize, or make available for implementation a cross-border arrangement. And the secondary consulting being those which provide some aid or assistance or consultation in the particular cross-border tax arrangement. Generally, the directive and the Bulgarian law provide for possibility for the secondary consultants to provide evidence they did not know or could not be reasonably expected to know that they have participated in a reportable cross-border arrangement, and on this basis be released from the obligation to file information for a reportable arrangement. Overall, apart from qualifying as a consultant, which I would say is not that difficult, in order for a consultant to be obliged to file information for a particular arrangement in Bulgaria, the consultant should also have some nexus to Bulgaria. This nexus includes either local residency or a permanent establishment in Bulgaria, or place of incorporation, or membership in a professional organization in Bulgaria. The Tax Procedure Code also regulates certain cases where a consultant is relieved from the obligation to file information. Without discussing all these possible cases, there are not that much, but I will focus your attention One of them, which I think may be important, and this is the case where the consultant is released from the obligation to file information if professional privilege applies to the consultant. However, even in this case, an obligation for the consultant arises to notify the other consultants on the arrangement, and for the obligation arising for those consultants or the taxpayer, if there are no other consultants, to file information on the cross-border arrangement. In addition, an obligation for such a consultant benefiting from professional privilege arises to provide information to the National Revenue Agency for the other consultants or the taxpayer, which should provide information to for the reportable arrangement, so that the revenue authorities are aware from where they or from whom they should expect to receive information for a particular reportable arrangement. As you see on the slide as well, there are several cases where the obligation to report shifts from the consultant to the taxpayer, and this is basically these are basically the cases where there is no consultant on the arrangement, including the cases where the arrangement is designed by an employee of the taxpayer. When the consultant on the arrangement is exempt from the obligation to file information, for example, due to the application of the professional privilege exemption, or when the consultant on the arrangement does not have nexus to an EU member state. It is maybe worth noting that an obligation to file information for a cross-border arrangement may also arise for a taxpayer who is not resident in Bulgaria and does not have a permanent establishment in Bulgaria. These are mainly the cases, for example, where the foreign taxpayer generates income or realizes some profits from Bulgarian sources without having any presence or permanent establishment in Bulgaria. The other thing which I would like to draw your attention to is that depending on the circumstances, a person may qualify either as a consultant or as a taxpayer. And this entirely depends on the involvement of the respective person in each particular particular arrangement, if it qualifies as a cross-border tax arrangement. And last but not least, it is good to remember that consultants and taxpayers may be both legal entities as well as individuals. So this does not apply only to legal entities, but these rules equally apply to individuals as well. Can we go on the next slide to briefly go through what should be reported? I'm not going to read all items of information which should be provided. You can well see them on the screen. Just it is worth mentioning that even in the interpretation of the information to be filed, there may be difference in the interpretation of the different countries. For example, if you look at the value of the tax arrangement, in one country, the value of the tax arrangement may be the value of the whole transaction, while for another country, the value of the tax arrangement may be the amount of the amount of the tax benefit or the tax advantage provided by the respective arrangement. So this is also an area which may give rise to different interpretations by different countries. Upon initial filing of information for a reportable cross-border arrangement, there will be a unique number issued for the particular arrangement, and this unique number will serve as an evidence that information for the cross-border arrangement has been filed to the competent tax authorities. An obligation is introduced for Bulgarian taxpayers to indicate in their annual corporate income tax return or personal income tax returns whether they make use of cross-border tax arrangements, and they will be obliged to indicate the unique number of the arrangement. Can we go on the next slide to see when the information should be filed? The general deadline is 30 days for filing of the information, and this 30 calendar days start to count from the earliest of the day after the reportable arrangement is made available for implementation, or the reportable arrangement is ready at the stage allowing its implementation, or the date on which the first step of the implementation of the arrangement has been made. The above deadlines apply to both consultants and taxpayers, depending on who is liable to report. Given that for the secondary consulting, for the secondary consultants, the reporting obligation arises within 30 days, beginning on the day after they provided their aid or assistance or consultation with regard to a particular part of a tax arrangement. A situation may arise where, for example, a secondary consultant providing tax advice on a part of an arrangement, an obligation for such a consultant may arise to report even before the primary consultant has the obligation to do this. And last but not least, I think we should mention something about the penalties for non-compliance. The penalties for non-compliance generally vary in the range of 2,500 to 5,000 euro per case of non-compliance. And the penalties provided for Bulgaria are far from the high end compared with other EU member states. However, apart from the pure monetary impact which the imposing of such penalties may have, the potential reputational issues for the companies and the advisors should be considered when it comes to non-compliance. So the rules for, as a conclusion, I would say that the rules for filing of information to the tax authorities with regard to the cross-border arrangements and the relatively short terms for this make me think that there will be drivers for certain changes in the internal organizations of both consultants and taxpayers, where systems to understand and report the transactions, reportable transactions, as well as to know what is being reported and where this is reported, may need to be introduced. And I think that these are the final words I had for this session. Thank you very much for your attention and your patience. And I'll be happy to answer any questions you may have either now, or if you want, we can chat after the webinar. Thank you.
Thank you very, very much, Alexander. I don't see any questions in the Q&A. Any questions from the panelists or from the attendees for Alexander? Probably Probably everyone will ask questions later. I suggest that we wrap up because we are about 20 minutes late from the officially announced end of the webinar. Thank you very much to everyone who joined us today for our first webinar on tax and business regulatory update. I would like to extend my thanks to all the panelists who adapted their presentation to the webinar style, and to thank them for their readiness to bring the event online. I would also like to thank all the attendees who bared with us for a little over 3 hours this morning. And last but not least, I would like to thank my team, and especially our new team member, Georgi Penev, who joined us last week. And this was his first official BBBA event. Well done, Georgi, and welcome on board. Thank you for bearing us with the technology. This is new for us, as well as for most of the presenters. We are learning along the way. I would like to encourage all BBBA members to stay in touch. The fact that we cannot see you for beer at the embassy or anywhere else doesn't mean that we are not here for you. So if you have any suggestions for any topics for other webinars, or for anything we can do as an initiative to support you with your business in these difficult times, we are here for you. Please call us on the phone or on Zoom or anything. And as you probably have noticed, we started this crisis management support call that we will be having every Friday until it is needed. The next one is tomorrow at 10 o'clock. So if you haven't signed up, you still have some time for that. And if you have a chance to fill in the survey about the government measures, we'll appreciate that. Thank you very much for everyone. And that will be the end of today's webinar. Have a good afternoon. Bye-bye.